We are now live. So, Dr. Maruta, you can take over.
Okay, hello everyone. Good afternoon, good day, good night, wherever you are around the world. Today we are going to have our next session related to the United Nations and the International Criminal Court. We are going today. We are going to have the participation once again from Professor Shipati from the Singularity University from India. Professor Milton Awar, founder and director of the Center for International Criminal Justice Africa. At the same time, we have Professor Rama Kudumela from India. Also, Manrit Kaur, she's an attorney for the. At the same time, it will be joining us Professor Frimpong from from Georgia, from the U.S. Also, Maria Mercedes Pisani on University in Italy. And finally, we are going to have the presence of Brian Ramafane. He's a researcher for ICR Justice Africa. Also, Consul Brenda Okode. She's a special expert in international law. She will join us from Sweden. And Ditaba Ransane. They both work for the government of South Africa. One of them worked for he is the director for SA Government Legal Service, and Malesala Leso is legal relations from the Department of Justice from South Africa. Okay, I hope no missing anyone, so we can start our conference for today. Professor Milton, do you want to? Hi, Professor.
Hello, Professor. After a long time, we are seeing you.
Alessandra Lanchotti. In a while, nice to see you.
Hello, everyone.
Hello.
Oh.
We are happy to have you with us today.
Me too.
Great.
I'll be listening though, rather than speak, because I have a problem with the tooth.
Oh.
So I'll be happy to listen. I will not intervene in the conversation.
Oh. All right. No problem. Okay. We can have Professor Dr. Sripathi, as usual.
Okay. I'll make a start. Now, today the theme for the discourse is the UN and ICC. And we are aware of the fact that the efforts of the states in the world to establish a permanent international criminal court predates the establishment of the United Nations Organization in 1945. In the sense, the states had made efforts and in fact signed a convention on the establishment of an international criminal court in the year 1937. But after 2 years, the Second World War started and the convention never saw the light of the day. But what is important is the efforts made by the states for establishing an international criminal court. And then after the Second World War, we have seen the Nuremberg trial, the Tokyo trials, and then the two ad hoc criminal tribunals, ICTY and ICTR, before the states again decided to establish an international criminal court. And in 1998, the states signed the Rome Statute, and in 2002, the ICC was established, and the Rome Statute also had come into force. Now, although the International Criminal Court has been established by the states which are members of the United Nations organization, yet the court does not come under the framework of the United Nations organization. The states that have signed the Rome Statute wanted the court to be away from the UN. They wanted the court to be independent and not get embroiled in the political workings of the United Nations organization. They wanted the institution to be totally independent, away from the UN. That was the idea of the state parties that have signed the Rome Statute. Now, Article 2 of the Rome Statute is very important because it mandates that the International Criminal Court sign a relationship agreement with the United Nations organization. And because of this obligation under Article 2, the court did enter into a relationship agreement with the United Nations organization. Now, there are two other articles of the Rome Statute, that is Article 16 and Article 54, Clause 3 and Clause E of the statute. Now, both of these articles have created a lot of controversy in recent times. Now, why do we say that Article 16 has created a controversy in recent times? Because Article 16 of the Rome Statute empowers the Security Council to make a request to the court to defer any ongoing investigations or investigations that are going to be taken up in future. The Security Council is given the power by the Rome Statute and Article 16. And why Article 16 came into controversy, I will discuss it later. Now, there are basically two primary issues which emerged during the drafting history of Article 2 of the Rome Statute and which are reflected in the relationship agreement. Now, these two issues are very important in the sense, the first issue is that while the two institutions are complementary with one another, in fact, they share a very close complementary relationship with one another, and yet the ICC is considered to be an independent institution away from the UN. Despite the complementary relationship, the ICC is considered to be away from the United Nations organization. That is one issue which was discussed thoroughly during the drafting of the Article 2 of the Rome Statute. The second issue is that there exists an obligation on the United Nations organization to cooperate and provide support to the ICC whenever required. So this is the second issue. Now, coming to the first issue of the relationship between the United Nations organization and the International Criminal Court that has generated so much of interest and controversy of the whole world and in recent times is the relationship between the ICC and a particular organ of the United Nations organization, that is the Security Council. What is the kind of relationship that exists between the ICC and the Security Council of the UN? Now, this relationship is governed by Article 16, which I already mentioned, because Article 16 of the Rome Statute clearly empowers the Security Council to exercise the power to make a deferral of any ongoing investigation that the ICC has taken up or where the ICC is going to take up in future. The Security Council can request for a deferral of these investigations. Now, the right to request the power, right to request of power of the Security Council under Article 16 is to suspend for a period of renewable 12 months any investigation or prosecution that has already commenced or about to commence. This is something that Article 16 clearly lays down, and which empowers the Security Council. If the Security Council believes that such suspension is necessary to restore or maintain international peace and security. So for the Security Council to exercise its power, Article 16 of the Rome Statute, the Security Council must firmly believe that it is necessary for the purpose of restoring or maintaining international peace and security. Only then the Security Council should exercise the power. So the Security Council must exercise extreme caution while exercising this power under Article 16. Now, this exercise and analysis of Article 16 had to be made because of the Darfur crisis. This question of the Security Council exercising its power under Article 16 or not came into prominence because of the Darfur crisis. And now we are all aware as to what happened in Sudan, and the president of Sudan, Omar al-Bashir, has been charged with war crimes, crimes against humanity, and genocide by the International Criminal Court. And the fact remains that it is the Security Council which has permitted the ICC to start an investigation into the crimes committed by the president of Sudan. Now, when the ICC commenced its investigations, in fact, it sought the permission of the PT1, that is Pre-Trial Chamber 1, for starting an investigation into the crimes in Sudan. This was in 2008. And in 2009, the ICC decided to grant permission to the prosecutor to start an investigation into the crimes committed by the president. Now, in retaliation, the government of Sudan, with the support of the US, not US, but Russia, China, and the African Union, and the League of the Arab States, clearly declared that the Security Council must exercise its power under Article 16 of the Rome Statute, that is, to defer the investigation against Bashir. So, when they put a lot of pressure on the Security Council to stop the investigations against the president of Sudan, the issue became a controversial issue. Now, the question is, if the Security Council, which has itself empowered the prosecutor to proceed against the president of Sudan, can it now, because of the pressure being exerted on it, request the ICC to defer the investigation? But on the contrary, the UK, the USA, and Croatia together said that this cannot be done because it would be a violation of the rule of law. They opposed on the part of the Security Council to request the ICC to defer the investigation. So this was the controversy that emerged. So, and another point that comes out glaringly is that the Security Council, as I mentioned earlier, itself has vested the responsibility to the ICC to exercise jurisdiction over the Darfur crisis. And this is because under the Rome Statute, since Sudan is not a party to the Rome Statute, an investigation by the ICC can be started only if the Security Council makes a referral. And the Security Council had made a referral to the ICC to start an investigation. But now again, the Security Council is under extreme pressure to defer the investigation. Now, the next issue is the question whether the Security Council should invoke Article 16 to request deferral or not. It's a kind of a debate. So now I would like the panel on this issue, whether the Security Council under Article 16 should exercise its power to request the court to defer the investigation against al-Bashir. It's a kind of a debate, whether it should or should not. That is the question before us. Because in my opinion, the of the Security Council under Article 16, as I stated earlier, should be exercised with caution. It cannot be exercised arbitrarily by the Security Council. And moreover, the power under Article 16 must be exercised only under exceptional circumstances or in times of emergency. Now, the contention of the government of Sudan was that the Security Council must exercise the power under Article 16 because the situation in Darfur was slightly improving because there was a peace process going on to establish peace between the warring parties in Sudan. And if the Security Council does not defer the investigation, that would jeopardize the peace process in Sudan. And therefore, the Security Council must exercise the power under Article 16. But in my opinion, as I stated earlier, Article 16 must be, the power under Article 16 must be exercised very, very carefully by the Security Council, in the sense, only under exceptional circumstances. Now, if the Security Council does not exercise the power under Article 16 of the Rome Statute, what would be the result? The possible result would be that they could kind of a retaliation from the government of Sudan. And the Security Council certainly has the power under Chapter 7 of the United Nations Charter to take enforcement action against any state that would commit a breach of peace. So the Security Council, without really interfering in the affairs of the ICC, can still take action against the state that is breaching peace or where it is committing crimes against peace or crime of aggression. The Security Council can still proceed. So that is my opinion. So I leave it to the panel to discuss the issue further. Thank you very much.
Thank you, Professor Shipati, for your intervention and sharing for us your concerns about the Security Council and Article 16 related to deferral of investigations or prosecution. Well, at this point, brought this to the desk in previous meetings. What I see here is that we have a problem in relation of the Rome Statute related to how the prosecutor office should work. I was checking, for example, the Criminal Procedural Code of the Netherlands, and this is something that we, the criminal defense attorney, always we push to get dismissed from a trial, also from an investigation. We always try to challenge how and how all what is constructed during the investigation is brought to the pre-trial chamber before going to judgment. And what I see here, if I'm not wrong, is that at some point uh, the Rome Statute doesn't have um, specific way the timing. Timing is very important in a criminal procedure. I mean, I don't have, I, don't- I don't have, I didn't have the opportunity to check the criminal procedure statutes that works on India, but I know that there is a common sense that it's very important the timing that the prosecutor has to investigate someone, and this timing is very important. In some places, they for a simple felony they have a timing of, I don't know, 60 days, and if it's a complex case, for example, a RICO case, I'm trying this the RICO formula from New York, that is related to corruption, it could take up to 90 or 180 days, depending. So if at that time the prosecutor doesn't have enough elements uh, uh, beyond any reasonable doubt to indict someone, the pretrial judge, that in some countries is known as the judge, the investigative judge, or the warranty judge, will decide that this investigation should be dismissed. However, I was doing some research uh, in the internet, and there is a book that a friend of mine passed me that is titled, and I will share you all, is Justice Denied, the Reality of the International Criminal Court. It's from David Hoyle. And in this book, Hoyle, he spotlight what happened in, I think, if my mind doesn't trick me, I think it was Uganda. We have it here. One moment, please. Was in during some investigations. One moment. Yeah, it was in Uganda case. That in some point the 3 years of investigation with at last that's with no any kind of grab, grabbing the case, and they have to dismiss it. At some point under his investigations, nevertheless, we need to confirm this. He says something. He says something like this: to say that Lubanga's trial before the ICC was a farce would be an understatement. The legitimacy of the proceedings was marred from the start by serious irregularities regarding the prosecution investigation. It is uses for intermediaries, and the credibility of the witness is presented. That's in pages 253 and 254. So what I see here is that the statute has one problem. I think, and I always have said this, is too much scholar for, in my humble point of view, as a criminal defense attorney in practice. It should be, on the other hand, it should have more specific aids, not only for the prosecutor office, also for how it should work, because the different investigation, no investigation or prosecution may be commenced or proceed with under this statute for a period of 12 months after Security Council is after the resolution adopted under Chapter 7 from the Charter of the United Nations. I mean, this is, from my view, is too much bureaucracy. I think the ICC should be more independent. If if if, if you follow my pace, it should be more independent as any court, with any court around the world, with the prosecutor office, and they should have more a better map on how to go after an investigation in an international level related to international crimes. So I guess that in this point of Article 15 and 16 related to the prosecutor office, it should be needed to be a change, and I think it should be done for the international legal community, and also I don't know how many there will. I don't know. The prosecutor office could ask for amicus curiae, for example, to the general prosecutor office of Belgium, their opinion, like, I don't know, like doing like an ISO 900 and compliance work, something like that. Okay, check this, is working, it's not, which are in what point we need to improve. Because what I see here is that it's very the procedure before the ICC prosecutor office and then the trial is very slow in comparison with what happens for example, in the Netherlands, in the trial. So the timing is the pace, or in Italy or in Spain or in Germany, when you present when the prosecutor office has this criminal complaint and they need to do this investigation, you know, the timing is very important. The timing is very important. You miss one point and the judge will waive to the rights of the defendant. So that's what I see here. I see here that the ROM's been built under this the Feindstrafrecht, the Germans call it, the criminal law for the enemy. And that was not the idea when 25 years ago they decided to build this international criminal system to bring justice to the world. I think that practically when one is named by the ICC as a international criminal charges, it's like he or she is already marked, and all, in my humble opinion, and all the investigation, the pretrial chamber, and then the following trials is a charade, because at some point, how beyond any reasonable doubt, they want to nail the guy and put him behind bars, and that's not the idea. The idea is that we need to have a real, very real adversarial, like the ones we had in the past in the Nurembergs and in the Tokyo tribunals.
You have 2 minutes. I'm
okay.
Just reminding you.
Yes, that's the idea. So we need to change. So for concluding my presentation, this point needs to be reviewed by it could be meant for that are part of the Rome Statute, and try to change under the field with street smart lawyers that know how it works. It could be defense attorneys, also the prosecutors, judges, former prosecutors. So what happened in the country with the timing, we can make this part of the procedure of the statute a more real based international criminal procedure code within the statute that is needed for doing the investigations. And we have a lot of jurisprudence about that, since Nuremberg up to the ad hoc tribunals that we discussed last Friday. I mean, this could be done for improving how the investigations are going in the ICC. So, summing up, in my opinion, the ICC should be more independent from the prosecutor office to doing their own investigations more like in any other country around the world, because the idea of the ICC is the court of last resort, but it have a relationship in the way it do their investigations on national court. So that's the how do you say, that's the mirror that it should work. So I think that we are in the time, and there are very good research about this that could be an effort of all the legal international community to bring this and to change it, because at some point, for me, for example, if I see like a witch hunt in some kind of investigations, and that's not good, and that's not good neither for the ICC, and gives ammunition for speeches like Trump or to the work of the prosecutor office. Okay, thank you. I pass the desk to Professor
Marota. Sorry for that, because we have revised the timing. It's necessary.
Yes, it's very important. Yeah.
15 minutes to allow, for finishing in good time.
We need to make our flags.
that was the news, so that we are able to retain also some participants. Some of the panelists are not able to come because we don't stick to time. But thank you so much for the presentation. Thank you, Professor Dr. Sripathi. It looks like you've covered most of the points I was to cover, but there are a few areas that I need to emphasize on. And thank you, Professor Dr. Alessandra Lanciotti, for being with us. It's great having you around here. It's great encouragement because you are part of all this process that we keep discussing. All right. I've received information from Brian. He's struggling to come on board. Thank you. It's nice to have you because we discussed what you physically went through. I'm very happy that you've come to witness the discussion. All right. Professor Dr. Sripathi covered a lot of important points. I want to say that this discussion could not have come at a better time than today, when we are celebrating 75th anniversary of the United Nations. So it's a very timely discussion. There are 2 points which were mentioned by Professor Sripathi, which I need to, the starting point here would be the question of Article 2 of the Rome Statute. Article 2 of the Rome Statute indicates that the court shall be brought into relationship with the United Nations through an agreement to be approved by the Assembly of State Parties to the statute, and thereafter concluded by the President of the court on behalf of the court itself. So that is the starting point. That's the starting statutory point for any relationship that the court has with the United Nations. And then further to that particular article, it was made good by an agreement that was later entered into, a relationship agreement that was later entered into between the court, the International Criminal Court, that is, and the United Nations. Briefly, my learned colleague has mentioned the key points about this agreement. This agreement basically tried to emphasize the independence and the cooperation of the two entities, meaning the International Criminal Court would act independently. They would respect the independence of the court, and the court would also respect the independence of the United Nations as an entity. And it came into force on the 4th of October, 2004. There were other drafts that were done and were brought before the ASP for approval. And finally, the United Nations also had to approve because it was two parties involved. And in the end, on the 4th of October, 2004, we had a working relationship agreement. It's a detailed agreement with a number of articles, essentially setting out how the two entities would cooperate and would be able to deal with issues that are of interest or mutual interest to both institutions. So those are critical points when we discuss the issue of the relationship between the United Nations and the court. Now, in the United Nations, we have organs. We have the United Nations Security Council, which is essentially the political organ anyway. And we have the UNGA, the United Nations General Assembly, also an organ within itself. But we'll find that as far as the International Criminal Court is concerned, the intercourse with the UN has been more with one of the organs, and that is the United Nations Security Council. As we shall see, there are a number of statutory provisions that govern the kind of relationship that the court would be having with the United Nations, and specifically the United Nations Security Council. And my learned colleague has touched on most of them, and I just want to touch on a few. I'm sure you would be interested to know how the complex issue of the crime of aggression is being dealt with. I'll try to touch on that as well. But very quickly, just to rush through, in a brief history, we'll note that the issue of the court, I just want to take you to 1 minute historical recap on the issue of the court, the coming into existence of the court. The first person to be able to moot out the issue of the court was a Swiss national called Gustave Mayonnaise. That was way back in 1872. This is the person who made a proposal, a formal proposal, that it was necessary to have an international criminal court. But it wasn't followed much after that. But certain events took place, as we know, the world wars and the establishment of the international military tribunals. All these, including the International Criminal Tribunal of Rwanda and the former Yugoslavia, all these now motivated or prompted the consideration for a permanent international criminal court. So we see that in the year 1948, the United Nations General Assembly charged the International Law Commission with the project of the ICC, of the International Criminal Court. So at its first meeting in 1949, that's a year after, the International Law Commission ascertained that the establishment of the International Criminal Court was both a necessary, desirable, and viable proposal. That was their conclusion as a commission. However, it was only in 1990, that's about more than 40 years after that proposal, that the International Criminal Court issue was revisited again by the United Nations General Assembly. That's when the United Nations General Assembly mandated the International Law Commission to be able to start working on and review the issue of the International Criminal Court project. And that is where we see a lot of systems now being unveiled and the process. So as I said, this was in 1990, but we know that from 1993, 1994, there were very catastrophic events that took place. There were mass killings and genocide that witnessed death in Rwanda and Yugoslavia, former Yugoslavia. So this fueled the whole process. And so we have, in 1997, that's now 7 years after it had mandated the International Law Commission. In 1997, December, the end of 1997, the United Nations General Assembly decided by Resolution 52/160 to hold a diplomatic conference of plenipotentiary on the establishment of the International Criminal Court. And this is the kind of conference that we find our learned colleague, Professor Dr. Lanshotti, was part of. So it was as a result of that particular decision that put in place the plenipotentiary on the establishment of the International Criminal Court. We have Dr. Sandra. She's not feeling well, but she's available. She's following the proceedings. So this particular conference was held between 15th of June and 17th of July 1998. So the conference went on, and they were able to successfully accomplish the adoption of the Rome Statute at the end of that conference, and that was on the 17th July 1998. So that gives us a brief background on how the relationship between the courts began, how it was given birth to. So the plenipotentiary, the diplomatic conference, was essentially the brainchild of the United Nations. It was meant to be able to generate a permanent international criminal court. We can say that after that, the court has been operating as an independent entity, able to carry out its own functions, but based on the authority that's provided by the Rome Statute. Okay, having dealt with that, as I said, my learned colleagues have also touched on other issues, Professor Dr. Spathi and Dr. Marota. I will just be touching on issues that I feel were not either touched or I feel I need to lay more emphasis. Now I need to focus more on, as I said in retrospect, the relationship is more with one of the organs, that is the United Nations Security Council. And my following discussion will revolve basically around the relationship between the ICC and the international, and the United Nations Security Council. The key points here are largely those that revolve around Article 16, and basically it's the issue of referral and deferral. Referral and deferral powers that are exercised by the UNSC, that is Security Council. Essentially, you'd wonder, because we have instances where the court, members of the court are not all the members, are not necessarily, or rather, let's put it this way, the United Nations members are not all necessarily members of the International Criminal Court. They do not all ascribe to the Rome Statute. So we have instances of people who are non-state parties or states which are not parties to the Rome Statute, but are within the United Nations. That introduces a very complicated equation on how the UN operates along with the International Criminal Court. All right, having said that, both entities, the United Nations Security Council and the ICC, are independent entities, we have to emphasize that they are independent and permanent. And the existence of the ICC does not necessarily depend on the whims of the United Nations Security Council, having been born by virtue of a statute, the Rome Statute. Okay, now my colleague mentioned some points and raised some questions, Professor Dwarakanath. The issue of the veto power. Within the United Nations Security Council, which has 15 members, the 5 of them exercise veto powers. Any one of them could exercise a veto negative vote, and that would paralyze the entire decision that will come in. But you find, in fact, the majority of those who wield the veto powers, the United States, Russia, we have Great Britain and others, the majority of those that sit within the United Nations Security Council with that veto power are not members of the ICC. But they are able to exercise control on matters that fundamentally affect the ICC. And that's a question that requires further discourse. One needs to ask themselves introspectively, how can members who really are not part of the ICC wield such powers that would have fundamental and significant effects on the operations of an entity? But that's for another day. As my colleague mentioned, we have instances. The United Nations Security Council has exercised that power of referral only in 2 cases. And all those cases have been from Africa. We have the case of Sudan, and we have Libya. And that it provoked concern among some quarters. The African Union, as my colleague indicated, had requested that the United Nations Security Council should be able to exercise the other power which goes with referral, which is the deferment, that they should be able to defer. There should be a deferral in terms of action for a further 12 months in terms of action based on the referral. But it appears the United Nations Security Council was very reluctant. And that raised a lot of issues. In the light of that, there were similar incidents that were taking place in Syria, and people are raising questions. How come the Syrian situation has not been referred to the ICC? We have cases like in Israel, the Palestinian question. So it has brought a lot of controversy indeed with the way that the deferral and referral powers are being exercised. We don't have on record, I don't have on record which deferral matter I can refer to, because so far we've had only referrals, those 2 referrals, which have not been deferred at all, and which are still before the International Criminal Court. Okay, one thing we need to note is that the decisions that the United Nations Security Council makes, those decisions are of a binding nature by virtue of Article 25 of the UN Charter. Unlike the decisions which are made by the General Assembly as a body, as a plenary body, most of the decisions of the General Assembly cannot be regarded as binding. They could be merely exhorting or just aspirational. But when the United Nations Security Council makes a decision, such decisions usually are of binding effect by virtue of that Article 25 of the United Nations Charter. So it's very critical to understand the kind of body that's having a relationship with the ICC. So any referral they make is of a binding nature by virtue of their responsibilities. And we should also look at how such referrals are made. They're grounded upon Chapter 7 of the United Nations Charter, which chapter actually empowers the United Nations Security Council to take all appropriate measures to be able to deal with threats of threats to international peace and security. So actually when the United Nations Security Council is making a referral, it would have already recognized that possibly what is transpiring in that country would amount to a threat to international peace and security. And that is one testing point. It would be challenged if at all any referral would not be meeting that, that standard. The other point we need to bring across, when we look at Article 13b, that is the essence, 13.6 of the Rome Statute. That is the basis that creates the relationship with the United Nations Security Council. We just saw the provisions, the statutory provisions under the United Nations statutory structures, but now I'm quoting such Article 13, subsection C of the Rome Statute. That is what brings in the intercourse that we have in terms of the referral power. It simply states that no investigations or prosecution may be commenced or proceeded with under the statute for a period of 12 months after the Security Council in a resolution, and remember these resolutions are binding or binding effect, adopted under Chapter 7 of the United Nations Charter. They have requested the court to that effect. That request may be reviewed by the Council under the same conditions. It has been argued by some scholars that really what happened here was the United States trying to protect itself, seeing that what it has done, it will make sure, it knows that the United Nations may have, the Security Council may have the power to refer a matter to the International Criminal Court. But at the same time, the same United Nations Security Council would have power to defer the operations, rather the prosecution of that particular matter for a period of 12 months, and even a further 12 months. As we shall see, there's a particular resolution I shall make reference to, where the United States actually brought out that position very, very clearly. It influenced the drafting of that resolution before the Security Council, and made it so clear. Initially, they had a draft which was not accepted at the drafting point. It was not accepted. It was so plain. It was so clear, trying to exempt the nationals of the United States from any act. They wanted that inserted in the Rome Statute, that the court shall have no jurisdiction whatsoever against the nationals of the United States. But anyhow, they managed to come in and influence because they knew they exercised the veto power. And I'm not just talking about the United States. I don't know what other interests the other parties had as well. But the idea was, if any of their nationals were brought before the court, they would have the power to be able to exercise those powers of referral and deferral to avoid any prosecution of areas of their interest. So it is a power game. It is really, those articles, the relationship is a very complex one. But nonetheless, we've only had 2 instances so far, as we said, with a gap of almost, I think, 7 years between them. And we've not had a very significant issue on the deferral so far. Now, it's important to know that the deferral, the way it is, it would be able to stop. That deferral power also can check on the prosecutor. If the prosecutor is pursuing a particular prosecution, the United Nations Security Council can step in and have the matter deferred for a particular period of time. And if for 12 months and a further 12 months, there's no specific definite end as to when those 12 months would stop. So it would be an indefinite, some kind of indefinite period. The way the statute is framed, you would think that actually the United Nations Security would request. It talks of requests. The United Nations would request the prosecutor to defer. But we know in reality that's not a request, as it is. It will not be a request. In practice, in theory, yes, the OTP would be able to look into the request and possibly let it down. But we know in practice, there are many ways in which the powers would make sure those requests are more of command. So as we said, most of the relationship we have is about how cases come before the International Criminal Court by way of Chapter 7 of the UN Charter via the United Nations Security Council. Now, the area that I feel I should be able to touch before I wind up, which I think, I'm not sure that my colleagues touched. If they touched, I just want to emphasize the issue of, we know that the crime of aggression came in. It has been a pending issue until the time of the review conference in 2010 in Kampala during the stock taking. That's when the definition of the crime of aggression was settled upon. But you should note that before even that time, already the United Nations had the mandate to be able to describe, to determine what is the crime of aggression. That is the United Nations Security Council. That is the position that was there and even still there, that the United Nations Security Council had the power to determine what amounted, whether a situation amounted to a crime of aggression. But the whole regime changed when we had that definition. Not much has changed though, because I'll indicate how the relationship has just changed a bit. With respect to the crime of aggression, the relationship between the prosecutor and the United Nations Security Council is a bit tilted, in the sense that we know that the crime of aggression had to take effect after the passing of it in 2017. 1 year had to elapse, and then not every nation that is a member, not every state that's a member of the ASP or member of the court is affected by those provisions unless they have actually ratified the new amendments. So the crime of aggression applies only to those states that have ratified and have taken into force, the amendments have come into force with respect to their states. We have a number of states that have not ratified, who are actually ratified the Rome Statute, but have not ratified the amendments to the Rome Statute with respect to the crime of aggression. So they will not be held accountable. you would not start holding them accountable by virtue of the new provisions of the crime of aggression. But how does the United Nations come in? The issue is usually when the United Nations Security Council has determined that a situation at a given place amounts to a crime of aggression, the acts are acts of aggression, then it is up to the United Nations Security Council to determine that, to make a determination that those acts amount to that particular thing, that particular set of crime, the crime of aggression. Now, what would happen? Usually, the International Criminal Court would wait to hear from the United Nations Security Council whether they have determined that a situation actually amounts to the crime of aggression. But the United Nations has time. Usually they would give it up to about, if after 6 months, within 6 months they have not made a determination, then the prosecutor would have to go ahead with investigations in a situation that it considers the crime of aggression has been committed. And what to do is to present the same before the pretrial chamber, make its recommendations, and the pretrial chamber would proceed with the decision on whether the matter should proceed. So usually there's a relationship here that's out of cooperation that the United Nations Security Council would have to determine that a particular situation it's dealing with amounted to the crime of aggression. That's a complex relationship in terms of how the United Nations Security Council handles issues with the International Criminal Court. So we can see that there's a check where for any reason the International Criminal Court considers that the UN Security Council is not proceeding within time. The 6 months has passed. It will proceed with its own investigations and present it before the pretrial chambers have indicated. But again, remember, the United Nations Security Council still has the power to intervene with any proceedings that the prosecutor is undertaking in terms of prosecution. So basically, I think those were the key points I wanted to mention. All these could be found when you look at Article 15 bis, Article 15 ter, Article 15 subsection, paragraph 7 bis, Article 15. All these discuss the issues that I've mentioned. I just want to go through them one by one because of time. But that is the critical issue that I feel needed to be pointed out in terms of the relationship. Otherwise, as far as I'm concerned, that's my presentation. There are a lot of questions that emerge from there that any of the panelists, my colleagues, the learned colleagues, might want to delve into. Thank you very much. Over to you, Dr. Sripathi, Professor Sripathi. I can see Dr. Marota is, I'm sure you might want to add on something to what I've just indicated.
Yes, Professor Milton. Now, when you speak of the relationship between the United Nations Organization and the International Criminal Court,
yes,
relationship actually depends upon the commitment of the United Nations Organization towards maintaining international peace and security in the world.
Yeah.
And the UN, when it was established in the year 1945, the Charter under Article 1 consists of 4 purposes of the UN.
Yeah.
Maintenance of international peace and security in the world. 2, to promote friendly relations among the nations.
Yeah.
3, to seek international cooperation in solving international problems of social, economic, and humanitarian character.
Yeah.
So these 3 purposes of the UN form the basis for the UN to maintain peace and security in the world. It is only when states maintain friendly relations, the question of war does not arise. Only when a dispute arises, states may think of war. When there are no disputes, no war. So in 1947, towards this objective of the UN, the General Assembly, that is Article 13, Clause 1, Clause A
Yeah.
of the United Nations Charter, which actually lays down the functions of the General Assembly. The first function is the General Assembly shall initiate studies in respect of areas which fall within the competence of the United Nations Charter. So, in pursuance of this particular function of the UN General Assembly, the General Assembly passed a resolution in 1947 for the establishment of an International Law Commission. And the International Law Commission was established. And when the commission was established, the commission was entrusted with certain tasks.
Yeah.
Initially, 3 tasks were given to the International Law Commission. One is to deal with law of the sea,
Yeah.
and to deal with crimes against peace. Initially, crime of aggression was called crimes against peace. So crimes against peace, because that was a burning issue for the international community when the United Nations came into existence. And also arbitral procedures. These were the 3 issues that were given to the International Law Commission. But as the Commission started dealing with issues and also prepared draft conventions in several areas. And one of the areas was with regard to the international convention, the 4 Geneva International Conventions of 1949, and also the 1982 Law of the Sea, not Law of the Sea Convention, but 1958 4 conventions. And UNCLOS 1, United Nations Conference on the Law of the Sea 1 in 1958, 4 conventions were signed, and the draft conventions were actually prepared by the International Law Commission. And apart from that, the crimes of genocide, that is the Convention on Punishment of the Crime of Genocide, was also, the draft convention was prepared by the International Law Commission. So in this manner, the UN had always been committed towards establishing peace in the world, and that ultimately culminated in the establishment of the International Criminal Court. And the states, as pointed out by Professor Milton, all the states which are members of the United Nations Organization are not parties to the Rome Statute. Because the UN consists of 193 nations which are parties, whereas the Rome Statute consists of only 123. So the remaining states which are members of the UN but are not members of the Rome Statute.
That's right.
So issues arise. So the relationship actually has been established in this manner, and the UN has taken a lot of effort for the establishment of the International Criminal Court. But unfortunately, because of international politics, the efforts made by the UN is not really being fruitful. The UN wanted to see the International Criminal Court prosper by performing its functions and for achieving the objectives for which it was established. But that does not seem to happen, at least in the near future, because of the kind of opposition that is being directed against the court by some of the most established and powerful countries like the United States. And then Israel has joined the bandwagon of opposing the International Criminal Court. So, despite all this opposition towards the court from some of the established countries, the relationship between the UN and the court will remain intact. And in fact, a few weeks back, I mentioned in one of the discourses that there is an acute need for the amendment of the Rome Statute.
Yeah.
This can help the ICC to perform and function better. So there is a need for the Rome Statute to be amended. It has to bring in more countries on board and ensure that these countries do not oppose the court in any action that it would take in the future. So with this kind of international cooperation from the states, the court can certainly perform better and also maintain its relationship with the United Nations organization. So that's my submission. And I thank Professor Milton for giving me the opportunity, and also the co-host, Dr. Marotta.
Thank you very much, Prof. That was very elaborative. You've really elaborated on those other points. So I hand you back to Dr. Marotta, who's not here. Now you can take over.
Yes, I'm here.
We're done with our presentations.
Thank you. It was a very useful presentation done by Professor Shipatri. An excellent one. Okay, so moving here in this consultation panel, I wonder if Professor Milton has something to add or has a question for Professor Shipatri. Another one?
You recall in retrospect, thank you, Dr. Marotta. I just want to reinforce on something that I've mentioned. The United States, you'll recall that when the Rome Statute came into effect, the moment it was the ratification instruments, the last instrument that met the minimum number of 60 was deposited with the Secretary General of the United Nations. They immediately came up with an act of parliament in the United States. And that act of parliament was to be able, it was Americans, to protect the Americans, nationals who were involved in activities outside America that would end up, entangling them with the issues of war crimes or any other crimes. That is very important to remember. But I also talked about a resolution. You'll see how the United States have been wielding this power. The resolution I referred to earlier was resolution number 1422 of July 12, 2002. This particular resolution was highly influenced by the United States before the United Nations Security Council. It effectively granted immunity for prosecution to United States nationals for their future acts. It is a resolution which was granting immunity prospectively, not retrospectively. In most cases, we'd have instances of retrospective actions. But this was contemplating that in any event in future, if any of the United States nationals do acts or omissions that would satisfy the definition of international crimes under the Rome Statute on UN missions, either in Bosnia or Herzegovina, such people would be exempted from action by the ICC. So that was the resolution I referred to in my discourse. It's resolution 1422. And that resolution also provided for deferral. In fact, it was that particular resolution in itself was deferred multiple times. After the 12 months, it took effect in any event from the 1st of July 2002. Therefore, it means that where one would be accused or charged under the Rome Statute, it would not naturally affect a UN citizen or national by virtue of that resolution. So that is also very clear and a clear signal of how the United States has been influencing events at the United Nations Security Council. Yeah, that's what I wanted to add. point that I just mentioned. Okay, Dr. Marota, back to you.
Thank you, Professor. Also, I have, I want to add, I was during, after reading a very short book I mentioned before, titled Justice Denied, The Reality of the International Criminal Court by David Hoyle. I found something here. That one moment, please. That is that in the book Discourse right now that we are discussing this, I also that I think it's also important in this discourse between the investigations of the ICC and the United Nations. Another issue that is very important is the timing for now that that is going to be appointed a new head of. I mean, how do you see this affect the continuation of the proceedings that are actually within the ICC? We're supposed to have this new prosecutor in the first quarter of the year, and until now there is no date to be appointed. Even though I also have a notification through LinkedIn from Victor Silonis. I think he's a candidate from Greece, and he's like doing some kind of campaign. I don't know. He wants to explain me a little bit more about his contribution as an appointed to the prosecutor officers. I don't know if is the head or other seniority level. So I want to ask rather Professor Shipati or Professor Milton. Also, do you see that this like stalling in the slow way of appointing the new head of the prosecutor office affects the way under article in a way the articles of the statute, I think was 16 and 15 that we were discussing, affects the way the prosecutor office should in charge their own investigation procedures, or you think that these work in separate courts? Okay, Professor Shipati.
Now, even if a new prosecutor comes on board, the situation is not going to change, because the US will be opposed, Israel will be opposed, because now the most important investigation on hand with the ICC is that of crimes, alleged crimes that were committed by the military personnel of the United States and their intelligence agency, that is CIA, in Afghanistan and outside the territory of Afghanistan also. So if the new prosecutor comes on board, he or she has to take up this particular investigation. So again, it would be a kind of a block for the new prosecutor also, because the countries with which he is dealing are very powerful countries, and the opposition that comes from these countries would actually derail the functioning of the International Criminal Court. But this should not discourage or disappoint the new prosecutor, because when he takes up the responsibility, then he should go ahead with this functioning and leave the results to the events that unfold. but he has to perform his job. This is what I can say.
Yeah, Prof, I would agree. I would agree with you absolutely. I think the safeguards that the United Nations, rather the United States, put in place right from the time, you remember I talked about the fact that the United States had made a proposal. They wanted a specific express provision inserted in the Rome Statute at the time of drafting, specifically stating that the Rome Statute will not, actually the International Criminal Court shall not have jurisdiction over the United States nationals. That was a very bold requirement. But that kind of proposal was never taken up. They resisted it and it was rejected. So what they did, after that, they immediately passed. You will see that immediately, as I indicated, as the Rome Statute was being adopted, was being ratified, they passed the American Service Members Protection Act of 2002. This act has been called the Hague Invasion Act. It's invading the Hague. Because what it did essentially was to provide for penal sanctions against any country that would take action, or any institution that would take action against United States nationals that are involved in missions abroad. But something very interesting, it provided an exception within the countries that would be affected. It said any country except the NATO states. You can see the bias there. So it is something which is political, highly political. The discourse and the intercourse between the United Nations Security Council and the ICC is purely political. Because they're saying, if any of your countries, if we realize any country gets our national into trouble, we shall unleash penal sanctions against that country. However, we exempt these particular countries. We shall not unleash penal sanctions against NATO because it has political, binding relationship with the NATO countries. So that one is something that's also clear to note. Just mentioned it in passing, but I wanted it to be brought. However, we should also look into the issue. When we look at the United States, we should not be blind to the fact that the politics, the internal politics of the United States also have profound effect on the relationship it has with the ICC. Because we know during the Republican Party rule, the Republicans have tended to be more conservative and have been more against the International Criminal Court. But we see that during the Clinton era and during the Obama era, there's been a more liberal approach towards the International Criminal Court. In fact, for the first time, the US was an observer party at the ASP. That was their very first time at the ASP, the Assembly of State Parties meeting, which was only during the Democratic Party rule. So we hope that if the Democratic Party comes into power, there could be other changes which are more friendly towards the International Criminal Court, rather than what we have seen under the Trump administration. Okay, that is it. Over to you, Marota. And I think we have only 2 minutes to wind up. So we can just, if there's nothing much, I think we can just wind up so that we're in time.
Yes, Professor Milton, thank you for your answer. Well, for summing up, in my opinion, what it needs to do is there should be more two communication between the ICC and Prosecutor Office and the Prosecutor's Office all around the globe. I mean, also it needs to be more empowered, the Prosecutor Office in countries, because this is something that I do in my research. So in the U.S., they have done a lot of trial investigation, and many of international U.S. criminals have been being submitted to justice in the U.S. So that point of view, I guess what it needs to be understood that the ICC needs to be court of last resort. And in the case of the US, there's need to be more compromised. For example, if there's going to be any doubt of trialing an American soldier or an American contractor or American citizen by the ICC, so we need to do the indictments and investigations within the US, in the US soil. So this long arm of the law that is in the jurisprudence and in their own law statutes in the US, that the law in the US will hunt any one of his citizens. So we need to, I think, a way to improve the relationship between the ICC and the US could be and should be more transparency and more empower of the prosecution in the US. So that can be, I mean, a gateway under this critical and tense situation between the US and the ICC. So in somehow through the General Attorney Office or the General District Attorney Office could, I don't know, start doing some if there have been some not military troop, but American citizen contractors committed international crimes in the US, I guess that if under any law, under any US statute and federal law, it could be it could be a start for a criminal investigation against these persons and be tried in the U.S. Court, and probably they could be have an indictment and probably be tried and go to jail. So I think I mean we need to be creative, and I guess if this venue is I don't know, in diplomatic levels, this proposal goes to the US, I guess the waters are right now. Thank you. I pass the desk to Professor Milton.
Thank you very much, Dr. Marotta. Thank you for hosting, and thank you, Professor Dr. Sripathi, for that very insightful presentation. It has been a very great way of marking the 75th anniversary of the United Nations. Thank you, all our viewers. Thank you for being with us. It was also nice to see Professor Lanciotti, who has not been with us for a while. She came in and we marked the 75th anniversary of the United Nations. Thank you, our viewers, and we hope to see you again next time. Bye-bye for today, and we'll see you again.
Thank you.